Hi everyone, welcome back to Let's Talk Legal with Karimi Chege. My name is Karimi Chege, an advocate of the High Court of Kenya and your go-to employment expert. This is Season 1, Episode 1 of Employment Law Unlocked, where we'll be talking about one of the benefits under the Employment Act, being sick leave. So what are the objectives of this episode? 1 is to outline the minimum number of sick leave days entitled to each employee per year. 2, what are the conditions that need to be met by each employee to qualify for sick leave? And 3, what happens in the event that the employee does not meet these conditions? So let's get straight into the episode. So what are the total number of sick leave days under the Employment Act? Section 31 of the Employment Act provides that an employee is entitled to a minimum of 14 sick leave days. The first 7 days with full pay and the remainder 7 days with half pay. Do note that this is the minimum requirement under law. That means there's nothing that stops an employer from providing more sick leave days to his or her employees. Let us now talk about how to qualify for sick leave. So sick leave is a conditional right, and the law provides that an employee should have worked for his or her employer for a consecutive period of 2 months to qualify for sick leave. That is actually the first condition under law. The second condition is that the employee should ensure that they notify their employer as soon as possible of their illness or their expected absence. Reasonable time depends on the situation, and in court, it is determined on a case-by-case basis. Once you notify your employer of your illness, they are entitled to ask you more questions to get more information about your condition or to know when they should expect you back to work. The third condition is that the employee should avail his or her employer with a certificate of incapacity to work. This certificate should be signed by a qualified medical practitioner. It should be addressed to the employer and not to whom it may concern. It should stipulate the illness that is being suffered by the employee, but should be careful not to divulge confidential medical information of the employee. It should also cover the entire duration of the employee's sick leave. Now let us talk about the employer's responsibility and non-compliance. So the employer is mandated by law to reasonably accommodate a sick employee. This would mean ensuring that you relieve this employee of some of the hard tasks at work, or even accommodate them by allowing them to go on half-day basis just to ensure that they recover well. Now, what happens in the event that an employee does not abide by the conditions under Section 30 of the Employment Act? If this happens, the employer is entitled by law or justified to terminate the services of this employee on the grounds of absconding work or absenteeism. However, the law provides that the employer needs to abide by the conditions of procedural fairness when undertaking this termination. These procedures are provided for under Section 41 of the Employment Act, which outlines that 1, the employer has to issue his or her employee a notice to show cause letter indicating the reason why they are contemplating to terminate their services. The notice to show cause letter should be duly served upon the employee in a way that the employee can be able to prove service. Thereafter, the employee should be given the right to respond to this notice to show cause letter. The law also provides that the employee should be called for a disciplinary hearing. And during this hearing, they should be allowed to attend with a colleague or a union representative of their choice. The law also provides that the employee should be notified of the disciplinary committee's verdict and be given a right to appeal. In the event that the appeal's verdict is to terminate the services of this employee, the employee should be provided with a termination letter by the employer. The termination letter should clearly indicate the reasons as to why the employer has decided to terminate the services of this employee. Thereafter, the employer should compute the terminal dues of this employee and issue the employee with a certificate of service. Let us now talk about the case of Helen Mwende Paul versus Lina Kantaria trading as commercial registrars. In this case, Helen was employed in 2019, and on 16th of May 2021, she got sick and was unable to go to work. On 17th of May 2021, she notified her employer through WhatsApp that she was unwell and that she would come back to work on 18th of May 2021. Her employer responded by telling her to come with a doctor's note, which she responded, okay. However, Helen proceeded to come back to work on 24th of May 2021 and was informed that she had been terminated and advised to pick her termination letter and terminal dues. The court was faced with the task of determining whether Helen's termination was done substantively and procedurally fair. So on the substantive fairness, it was noted that Helen failed to avail her employer with the certificate of incapacity to work, and the medical reports that she availed court only indicated that she had been treated on 16th of May. They did not cover the entire period when she was on sick leave. Therefore, the court found that she had actually absconded her duties and that the employer was justified to terminate her employment. In regards to procedural fairness, the employer informed the court that he had issued Helen with a notice to show cause letter and she had failed to respond to the same. However, the employer was unable to provide evidence to prove that he had effected service of the notice to show cause on Helen. Therefore, the court found that the employer had not abided by the conditions of Section 41 of the Employment Act in regards to termination. Therefore, inasmuch as Helen had absconded her duties at work, she was awarded the sum of 97,500 for unfair termination since her employer had failed to terminate her in line with Section 41 of the Employment Act. What can we learn from this case? It is imperative for an employee to abide by the conditions of Section 30 of the Employment Act when applying for sick leave. Failure to which, your employer will be justified to terminate your services on the grounds of absconding, work, or absenteeism. What about the employers? It is imperative that you abide by the provisions of Section 41 of the Employment Act when seeking to terminate an employee on the grounds of absenteeism or absconding of work. Failure to which you will be found to have unprocedurally terminated such an employee. That marks the end of episode 1 of Employment Law Unlocked, and stick around for episode 2 where we find out what happens once you exhaust your leave days. Thank you so much for watching and see you on the next one. Remember, information is power, legal knowledge is freedom.